Good afternoon or good morning to friends joining from the US, and welcome and thank you for joining us for our annual Fox-Williams Data Protection Update. And it's hard to believe that in just a few days we shall be celebrating the 7th birthday of the GDPR. How time flies. Well, my name is Nigel Miller, and I'm one of the partners in our tech and data team. And I'm very pleased to be joined today by my colleagues Claire Bowler and Arjun Majumdar. And here's what we're going to be covering today. So Claire's going to kick off with a look at some of the recent cases involving data protection. I'm then going to look at recent enforcement actions by the regulators and what are the top 10 lessons that we can learn from them. Arjun will then look at what lies ahead in terms of key changes proposed in the Data Access and Use Bill, which is currently going through Parliament, and where we are on AI regulation. So although there's a lot of detail on each of these issues, within this hour, we're going to try and keep things relatively high level. Please do submit questions in the Q&A function. We'll do our best to answer either as we go along or at the end. But we do have a large number of people on the call and we may not have time to address all of the questions. So please do contact us directly afterwards by email or otherwise. And if you need any more help or information, we'll be more than happy to respond in the coming days. The webinar is being recorded. You can't be seen or heard, but hopefully we can. And we will circulate a copy of the slides and also a link to the recording. So there's no need to try and scribble notes as we go along if you don't want to. So without further ado, handing over first to Claire to a look at recent cases involving data protection.
Thanks, Nigel, and good afternoon, everybody. As Nigel said, I'm going to give us very much a whistle-stop tour of some of the cases that we think have been particularly noteworthy over the past year or so. So kicking things off, next slide, please, with Ashley and HMRC. So Mr. Ashley is Mike Ashley, the somewhat infamous individual. He submitted a DSAR to the HMRC in 2022 asking for access to all the information that HMRC held about him, and this was relevant to some investigations that the HMRC were conducting regarding tax treatment of properties that he owned. Mr. Ashley argued that the HMRC's response to his DSAR was incomplete and inadequate and claimed it didn't comply with GDPR requirements and brought a claim subsequently in the High Court. So just rewinding back to basics slightly, what is a DSAR? So a DSAR is a data subject access request, and it's a legal right under Article 15 of the GDPR. And this allows individuals to ask organisations for a copy of their personal data and an explanation of how it is processed. So employers probably most commonly receive them from ex-employees or in the middle of the employment tribunals. That's probably when you've most heard of them. Another key bit of law is the definition of personal data, in this case under the GDPR, and that is any information relating to an identified or identifiable natural person. So the key point to note there is that it includes direct information, such as someone's name, as well as indirect information. So that's information that may identify a person when paired with other data. So think of it like a car registration plate. If you pop that into the right search engine, you would then be able to identify an individual. So what happened? The court did mostly rule in Mr. Ashley's favour, but with a few important clarifications. So the court said when deciding whether information qualifies as personal data and responding to the DSAR, you should consider the context, purpose and effect of the information. And a key point to note is that the court actually decided that the HMRC's internal decision-making around Mr. Ashley's tax liabilities didn't meet this threshold and was not personal data. Another point that court made was around who responded or what part of the organisation responded to the DSAR. And it was actually only initially the department directly dealing with Mr. Ashley's tax inquiries that they did the DSAR with. And the court clarified that it actually applied to the whole organisation, so the whole of the HMRC. And it was the whole organisation's responsibility to coordinate across able to provide the complete data. HMRC argued that complying fully with the DSAR at the time would have been unreasonable or disproportionate, and they also said that Mr. Ashley's request was too vague. And the court gave very short shrift on these arguments and said that the onus is on the data controller, so HMRC in this case, to prove this disproportionality or this unreasonableness. And if they believe a DSAR request is too vague, that it is on them to seek clarification from the data subject. You can't just have, as a blanket ruling, not respond to things fully. HMRC also tried to only comply by providing snippets of text. So it was just like bits of text just showing Mr. Ashley's name or his initials. And unsurprisingly, the court ruled that this wasn't sufficient. And in responding, you have to provide information in a way that's concise, transparent, intelligible, and easy for the recipient to access. So key takeaways: DSAR applies to the organisation as a whole, not just a specific department directly dealing with the individual. Burden is on the data controller to prove that responding would be unreasonable, disproportionate if you're arguing that. And the meaning of personal data can be very wide. So there might be quite a lot more caught under that DSAR than you initially thought. So a slightly different case here, and in fact, a case that settled. This was involving Ms. Tanya O'Carroll, who is a privacy campaigner, who exercised her legal right to object under the GDPR to Meta/Facebook profiling practices for the ads that you see down the side of your screen on your Facebook. She argued that Meta's targeted advertising violated her privacy rights by processing her personal data without explicit consent. Meta countered this by claiming that its ads targeted groups, sort of the demographic that she fell under, and not the individual, and therefore didn't qualify as direct marketing and therefore requiring that compliance. So the pieces of relevant law here are PECA. So under Privacy and Electronic Communications Regulations, or as we like to call it, PECA, direct marketing requires specific informed consent from individuals, meaning they have to actively agree to receive electronic communications like email or text promotions. So that's often that like tick box at the end of your checkout. And the GDPR separately gives individuals the right to object to the processing of their personal data for direct marketing purposes, and businesses have to cease such processing immediately upon receipt of such an objection. Another key point under the GDPR is the legitimate interest lawful basis. So one of the lawful bases that you can process data under is a legitimate interest as well as consent. And this is what Meta was relying on for its data processing in this context. So interestingly, in this, the ICO, so Information Commissioner's Office, the data protection body, intervened, issuing a legal opinion stating that profiling for targeted ads is directly connected to direct marketing, and this means individuals must have the ability to opt out. So unsurprisingly, as a result of this, Meta decided to settle, agreeing to stop using Ms. O'Carroll's data for targeted advertising, and it's also begun exploring subscription-based ad-free models for Facebook and Instagram users in the UK. So what could this mean for you? It could mean that targeted advertising is on its way out, and you might need to consider alternative revenue streams like Facebook has, like Meta has. And it might mean that you need to think closely before using legitimate interest as your lawful basis for any data processing, and think about whether or not your legitimate interest weighs up correctly the rights of the individual at the same time, which is a key sort of proportionality balance you should be performing. Next, I'm going to talk about two representative claims, so class action claims involving data breaches. So the first one I'm going to discuss is Prismal and Google, and this arose from the alleged misuse of patient data transferred from an NHS trust to Google UK and DeepMind. Prismal sought to bring an opt-out representative action on behalf of all the affected individuals, which was approximately 1.6 million individuals whose medical records were transferred to Google. This data was used to develop an app called Streams, used for identifying and treating acute kidney injury. Say that 3 times fast, but also for broader purposes beyond direct patient care, in respect of which it was claimed by the individuals that no consent was given, and damages were claimed for the loss of control of the private information. So there's two pieces of relevant law here. One is around representative actions and how they can be brought. So this is under CPR Rule 19.8, which is formerly 19.6. It's more well known under that. And that allows one individual to act on behalf of others with the same interest in the claim. And these actions require all class members to have that same interest and a shared real prospect of success in the claim. So this, as mentioned, was brought under the tort of misuse of private information, which has been proffered as a potential alternative route for representative actions in data breach claims. So some key elements of this tort is you need to prove whether the claimant has a reasonable expectation of privacy in the relevant information, and that the expectation is outweighed by a countervailing interest of the defendant. And so in this case, the claim was rejected at the High Court and then also subsequently in the Court of Appeal late last year, as the court found that not all the members of the proposed class would have the same reasonable expectation of privacy regarding the mass transfer of patient data. And factors that impacted this was the nature of the data, how it was used, and an individual's sensitivity to its transfer. And all of this varied too widely amongst the class members. And so this variability, as well as the variability in harm experience, undermined Prismal's ability to meet that strict same interest requirement to bring the representative action. And the claimant's argument that there would always be a blanket expectation of privacy was also therefore rejected. So our second representative action is Farley and Paymaster. So this is slightly different. Paymaster trading as Equinity, and Equinity is a pensions administrator company, and it was providing this service to 500 odd current and former officers of the Sussex Police Force, and they also sought damages for the misuse of their private information and breach of the GDPR because Equinity had sent out envelopes containing their pension benefit statements to their former addresses rather than their current addresses, and these statements included information like their name, their date of birth, their national insurance number, their salary, and the fact that they were occupied as police officers. The majority of these officers claimed in respect of the risk that third parties could have access to these envelopes, and they claimed there ought to be an inference that their envelopes had likely been opened, and then claimed for distress and anxiety caused by that perceived risk of falling victim to identity theft. And then the remaining 14 officers asserted just that the envelopes were in fact likely to have been opened. So in February last year, most of these claims were struck out by the judge, and these were all of the claims where they didn't argue the envelopes had actually been opened, so all but the 14. The judge said that the claimants had failed to present sufficient evidence of actual harm, and it clarified that a viable claim for misuse of private information requires demonstrating that the private information actually has been accessed or read by a third party, and that that's the evidence that needs to be proved by the claimants. So the Court of Appeal has actually granted permission to appeal this decision, and it's scheduled for next month. So we'll wait and see what happens there. What both these cases demonstrate is the need for the claimants to present clear evidence of harm resulting from a data breach, which is often quite hard to prove if there's been no obvious financial detriment or emotional detriment. And this raises the bar for advancing group actions in this context. And it also shows that courts are very cautious about opening the floodgates in terms of data breaches, and that they will be prioritising proportionality in any sort of group litigation process, whether data breaches or otherwise. Moving on to my last case in this very, very quick tour, or stomp through the last year's noteworthy cases. This one is around RTM, a recovering gambling addict, and Bonterre, which is a subsidiary of Sky Betting and Gambling. And RTM was engaged in these online gambling services provided by Sky Bet and brought claims alleging misuse of his personal data for online marketing because Sky Bet had been profiling RTM's gambling behaviour, such as his time spent on the site, money invested, and losses, using cookies and other tracking technologies, and targeted him with personalised direct marketing, including emails sent twice daily. RTM claimed he had not given legally effective consent to this profiling or direct marketing. He had ticked consent boxes without reading privacy notices or understanding the implications due to his gambling vulnerability. So his gambling addiction was central to his claim, as he was alleging that Sky's practices exploited his vulnerability by using his data without having proper safeguards or informed consent. So the key bits of law here are around consent. So under GDPR, consent has a very high standard. It's got to be freely given. So individuals must have a genuine choice and not feel pressured to consent. It has to be specific. So it's got to relate clearly to the defined purposes for which the data is being processed. It's got to be informed. So data subjects have to understand how their data is being used. So that's often through the privacy policy. And it also has to be unambiguous. So it involves a clear affirmative action, like ticking that checkbox. There's also additional compliance around handling vulnerable individuals. GDPR covers a lot around children, but the ICO also has guidance around generally vulnerable individuals, and this includes problem gamblers. And this requires businesses to provide additional safeguards when processing data belonging to vulnerable individuals and ensuring that their autonomy isn't impaired as a result of such processing. So unsurprisingly, the High Court found that Sky's approach compromised the autonomy of RTM and ruled that implicit consent from participation in services failed the legal test for valid consent under the GDPR. They emphasised that consent cannot be bundled into terms and conditions or assumed from that participation in the service. They also criticised Sky's profiling practices, which targeted vulnerable individuals like problem gamblers without proper safeguards or legitimate purposes. They were found to be in breach of data protection laws, and as they failed to meet GDPR standards for obtaining consent for online marketing. So a couple of key takeaways. Consent mechanisms need to include explicit opt-ins and include clear information about how the data will be used. And there should be simple methods for withdrawing any consent at any time. And it should be a nice and easy one, but avoid exploiting vulnerable individuals. You should be implementing safeguards to ensure that your data protection practices account for vulnerabilities and avoid exploitation and tailoring processes to meet the need of vulnerable individuals. That's all from me. Handing back to Nigel.
Thank you so much, Claire, for that tour de force of the recent cases. My slot now is on regulator actions and what we can learn from them. You will have heard of the so-called Chinese curse. May you come to the attention of the authorities. It sounds like a blessing, but of course it's anything but. In the world of data protection, the attention usually comes from the Information Commissioner or an EU supervisory authority, and that's not the sort of attention that most organizations would want. I'm going to look at what we can learn from the ICO and EU supervisory authorities over the past year. We'll look at what sort of complaints the ICO receives, where organizations have been getting it wrong, and what sort of enforcement actions have been taken. Most importantly, I'm then going to try and draw some practical lessons, a bit of overlap with what Claire's covered on the cases, and some takeaways in order that we can improve compliance and reduce risk. So first of all, let's look at the data on complaints. In 2024, the ICO handled around 34,000 complaints. And the figures over the past years show a steady upward trend. It's a reminder that data protection and GDPR are now firmly on the consciousness of individuals, whether they are in their capacity as employees, consumers, or the general public. So what were people complaining about? Well, the issue that attracted the most complaints, perhaps unsurprisingly, was data subject access requests, or DSARs. A huge 42% of complaints related to DSARs, whether about delays or ignored requests or incomplete responses. And one of the recurring themes is organizations misunderstanding what qualifies as a valid DSAR. It needs to be remembered that a DSAR doesn't need to be in any particular form, and requests don't need to mention the words GDPR or DSAR by name. Any request for the information you hold about me counts. The DSAR can be submitted by email, from a website form, via social media, or orally by telephone. Failing to spot or log a DSAR has been a significant cause of these complaints. The other big area for complaints was, of course, data security breaches, which made up 15% of the cases, and more about that shortly. So what happens when complaints reach the ICO? Well, most cases don't end in any formal action. About 64% of cases are resolved without any action being taken, which is quite encouraging. But that means that around 36% of complaints do result in some sort of intervention. Of these, only a few lead to fines, which shows perhaps that the ICO's approach is generally quite pragmatic, looking for a resolution by way of improvement in compliance rather than a penalty or punitive resolution. But even if the ICO takes no action, they will keep the complaint on record in order to build up a picture, which could be then used to take action in the future if they receive more complaints about the same organization. So let's go further and look at where enforcement action is taken by the ICO. And they have taken enforcement action against dozens of companies. So the two big themes, again, maybe unsurprising. First of all, data security issues leading to personal data breaches. Coming back to this one in a minute. And then the next one, unlawful direct marketing, especially spam emails, spam texts, and cold calling. The top 6 ICO fines issued by the ICO since January 24 are shown on the slide, and I'll just maybe pick out a couple of them. First of all, the Advanced Computer Software Group, they were fined 3 million. This involved a ransomware attack that exposed sensitive data, blamed on inadequate security measures. The case is interesting because it was the first major fine against a data processor. Up until then, most enforcement actions relate to processor failings, generally focus on the data controller's failure to vet the processor. Advanced Computer Software was a key NHS supplier when a ransomware attack exposed data relating to 79,000 individuals. The ICO investigation highlighted a number of failures, more on that in a moment. But just to highlight the potential implications for data processors, first, just to reiterate that data processors do have direct obligations under the GDPR with respect to data security, which means they can be directly fined. Processors have to be able to demonstrate robust data security because these days customers are more and more intensifying their due diligence on their processors. And then there is potential contractual fallout as well, because as well as the risk of penalties from the regulators, processors could face contractual claims from their controller customers, where they may have either uncapped liability or commonly these days a super cap liability for breaches of data processing agreements. The other one, just to pick up, would be the HelloFresh fine, which was 140,000 for a campaign of spam emails and texts without proper consent, violating the privacy regulation PECA, which Claire mentioned. The ICOs found that the company's messages were sent based on an inadequate opt-in and lack of specific and informed consent. So that one was ICO actions in the UK. Just looking at what are the top 6 fines in the past year from the EU supervisory authorities. It looks a bit more serious. There are multi-million euro fines here, and perhaps a slightly different focus. The EU focus on unauthorized data transfers, international transfers, again, inadequate consent, and insufficient safeguards for sensitive information. So TikTok, 530 million from Ireland for unlawful transfers of data to China. Uber, again, a fine for transferring data to the States. And LinkedIn, 310 million from Ireland for carrying out targeted advertising without a proper legal basis. So what can we take from all of this? I've sought to extract the top 10 takeaway lessons that organizations can learn from these EU and UK complaints and regulatory fines, maybe to help identify compliance priorities and risk management. And a lot of this overlaps with points made by Claire in relation to the recent cases. So I'd say the number one thing about data protection, if you want to summarize the GDPR in a few words, I would say, don't lose the data. So cybersecurity, data security is probably the number one thing. If you shop online at M&S or the Co-op or Harrods, you'll be very aware that having substantial resources alone does not protect you from cyber attack. The recent cyber attacks have shaken up the retail industry, highlighting their vulnerabilities. Bank of America estimated that the attack is costing M&S £43 million a week. As well as these costs, there's of course reputational damage, loss of customer goodwill, and devaluation in share price. In addition to all of that, it may be that even though M&S was the victim of the attack, it could also face a fine from the regulator for putting consumer data at risk. And it's not just about these big brands. The ICO expects even small companies and medium companies to follow best practice. The particular items that the ICO highlighted in the advanced computer software case from a data security point of view were, first of all, a lack of multi-factor authentication, MFA, so the regulator regards that as important. Untimely patching. The attack involved the exploitation of a known vulnerability for which a patch had been available for some years and it wasn't implemented. A lack of vulnerability scanning, although tools were in place, they weren't used. A lack of a strong password policy, which helped expose the organization to relatively unsophisticated attacks. And also the ICO criticized organizational measures. Outsourcing IT management and security does not make you immune from penalties. If you outsource IT or cloud services, you remain responsible for ensuring the right security measures are in place. Number two, I've put as breach notification or timely response to data breach. On the slide on the ICO fines, there was one for £60,000 for a law firm, DPP Law, which was late in reporting a cyber incident. So the second top tip is about how you respond when things go wrong, and inevitably things do and will go wrong. So first you need to identify if there has been a personal data breach as defined by the GDPR. It's not just about the dramatic hacking into your systems. It's any incident that could lead to the accidental or unlawful loss or unauthorized disclosure or access to personal data. It can be something as simple as losing a device which has unencrypted data on it, easily done, or most commonly, sending an email to the wrong person. 70% of breach notifications to the ICO are based on human error. And the top one of those is sending an email to the wrong person. And yes, I'm sure we've all done it. If you're the controller and you suffer a breach, you have to report it to the ICO without undue delay and, where feasible, within 72 hours. You don't have to notify the ICO if you're sure the breach is unlikely to result in a risk to the individuals, but that decision needs to be justifiable. And if the breach is likely to result in a high risk to the individuals, say identity theft or financial loss or sensitive information, then you must also notify the affected individuals promptly. So the bar for notifying individuals is quite a bit higher than that for notifying the ICO. So it may be that you're required to notify the ICO, but not the affected individuals, all based on that very speedy risk assessment that needs to be carried out. If you're a processor and you suffer a breach, you don't have to notify the ICO, that's the controller's responsibility, but you do have to inform the controller without undue delay. Often that is made more specific in data processing agreements, that it might be 24 hours or 48 hours. Regardless of whether or not you have to report a breach, all breaches have to be logged internally in a breach register. So while not all breaches need to be reported, they all do need to be assessed, and speedily. Having a clear process in place is vital for that. You don't want to be making it up as you go along when the clock is ticking. So the important takeaway is to have in place a data breach incident response plan so everyone can understand their obligations as and when the situation arises. So number three, I've got responding to DSARs, and Claire referred to this in some detail in relation to the Ashley HMRC case. The best practice point here to take away is to have an internal DSAR policy to ensure all your staff understand their responsibilities. It helps identify when a DSAR comes in and enables consistent and timely responses, and reduces the risk of non-compliance that could lead to complaints or sanctions. Number four, on marketing, again, getting marketing compliance right. The ICO is very fond of fining companies who send marketing emails or texts without proper consent where consent is required, or ignoring unsubscribe requests. Again, Claire referred to this in relation to the O'Carroll and Meta case and the Sky betting case. Some quick points just to remember, particularly PECA, which applies, the privacy regulation sits alongside GDPR, requires consent for direct electronic marketing. That consent has to be valid. It should be specific, informed, freely given, and easily withdrawn. Pre-ticked consent is generally not going to be compliant. Remember that consent doesn't last forever. It needs to be regularly reviewed and refreshed, especially if you change what you're doing with the data. It's good to keep records of when, what, and how consent was given and any withdrawals so that you can demonstrate compliance in the event of any complaints. And where consent is not required, and if you're relying on legitimate interests, then it's good practice to conduct and document a legitimate interests assessment, or LIA. So number 5 I've got is respecting data minimization and retention principles, some of the key data protection principles. TikTok was fined 530 million euros, not just around the international transfers, but also because of excessive data collection and retention of personal data. The data minimization principle is that data collected should be limited to what is necessary. So clearly define why you need data before collecting it. If there's no clear purpose, don't collect it. Necessary in that context means strictly required for the defined purpose. It doesn't mean it's merely useful or nice to have. It has to be strictly necessary. And the storage principle requires that you keep data for no longer than is necessary for the defined purposes. And also, holding less data reduces your risk and simplifies compliance with things like data subject access requests or erasure requests. So a couple of takeaways. Data mapping, you can't manage or minimize what you don't know exists. So maintain an up-to-date data map to understand what you hold, where and why. Define and implement retention periods based on the data's purpose and bearing in mind your legal record keeping obligations as well. And when data is no longer needed, ensure that it is anonymized or securely deleted. And avoid just-in-case hoarding. Retaining personal data without a specific ongoing purpose is, again, a compliance and data security risk. The last 5, 6 to 10, I've summarized as compliance culture and emerging risks. Number 6 is proper safeguards for international transfers. Mentioned a few times, the subject of quite substantial EU fines remains under scrutiny from the regulators, especially in the EU. Arjun's going to touch on this in a minute in his session on international transfers. On accountability, not just about having policies in place, but it's about embedding data protection into your daily good practice. Most breaches, as I mentioned, involve human error. That's sharing the wrong data, succumbing to a phishing attack, or poor data retention practices. Regular training and data audits can help manage that. In the M&S attack, it seemed that social engineering played a role. Hackers impersonating IT staff to trick help desk personnel into resetting passwords and thereby gaining access to internal systems. So a heightened staff awareness of these risks might help minimize the risk of these things happening. Number 8, apply extra care when handling children's data or special categories of data. Processing sensitive data demands additional safeguards. Special category data, data on health, religion, biometrics, ethnicity, or sexual orientation and the like, involves having an additional legal basis in order to process it as well. So a higher standard for compliance. The recent fine of €500,000 on the Spanish healthcare provider Marina Salud highlights the risk of not having adequate controls over sensitive data. Number 9, engage proactively with the regulators. If you do get contact from the ICO, bear in mind that the regulators favor timely engagement and cooperation. In many cases, that can lead to reduced penalties or an informal resolution if you're transparent and responsive and take the remediation seriously. And finally, the ICO has signaled a growing focus on children's privacy and AI governance. Arjun is going to be looking at AI a little bit more in a moment. And so in conclusion from me, if you do come to the attention of the authorities, remember, most complaints don't need to escalate to enforcement or fines. Um, Often your best defense is to have clear policies, robust processes in place, and a culture of accountability. And if the regulator does get in touch, respond promptly, cooperate fully, and show that you're taking compliance seriously. That's it from me, and I'm now going to hand over to Arjun.
Thanks, Nigel, and thank you also, Claire. What I'm going to do in this last slot is a high-level regulatory update, and in particular, I'm going to be looking at the upcoming data protection legislative reforms. I'm particularly going to focus on the UK Data Protection Reform Bill because there are and have been developments here to update you on. But I'm also going to talk about towards the end where we are on AI regulation, both in the UK and in the EU. So in last year's annual data protection webinar, Claire talked about a data protection reform bill that was introduced by the previous government. It was back in 2023, and this time last year, that bill was going through various stages of the parliamentary legislative process. Obviously, we've had a general election since then and a new government. So what happened was that the bill, which the previous Conservative government introduced, did not make it through what's called the parliamentary wash-up period. So it didn't survive the election and it was ultimately scrapped. However, in October last year, the Labour government sort of resurrected the bill and introduced a very similar looking, not the same, but similar looking bill, which is now called the Data Use and Access Bill. And it's actually at the towards the final stages now. So it's looking increasingly likely to become law very soon in the UK. And the prediction is that it will come into force, sometime later this year. The bill is long. It's just under 270 pages. What we've tried to do here is drill down into those areas which we think are most relevant. The reason for its length, by the way, is that a lot of changes are sort of wider public sector changes. And sort of larger changes that are being considered on a kind of national scale. So, for example, the bill introduces the potential for what are called smart data schemes. We've seen this develop already in the UK with open banking, and one of the key aspects of the bill is to provide a framework which will not only help continue to grow the open banking sector, but sort of extend the principles of open banking into other sectors like telecoms and utilities. And the bill also has plans to improve ID digital verification services online. There are plans to reform data schemes within the NHS and in law enforcement. And this is all part of wider plans to remove certain kind of perceived frictions when it comes to data sharing. And ultimately kind of build trust in the public to make use of data services better. And the idea is to kind of help boost the UK economy. So we'll have to wait and see in the long term how these schemes will come into fruition. But for now, I just wanted to focus on some of the key forms that are being made to the existing data protection law, particularly the GDPR and PECA, as Nigel and Claire have touched upon already. So the first is legitimate interests. So those familiar with GDPR compliance will know that to process personal data, you have to have a lawful ground or a lawful basis. Claire and Nigel have mentioned this already. And legitimate interests is frequently used as a lawful basis for various data processing activities. And what the bill looks to do is to provide a list of certain activities which automatically qualify as being for legitimate interests. And these are what are called recognized legitimate interests. But it probably doesn't change what you do much in practice already, because that list of recognized legitimate interests is not particularly long. It's centered around things that are necessary for crime prevention, national security, protecting vulnerable people. And of course, if the activity is not on that list, it doesn't mean you can't rely on legitimate interest. You still can. And as Nigel mentioned before, best practice would be still to carry out what's called a legitimate interest assessment to determine whether you can rely on it as a lawful basis. So that practice really looks set to continue. So we're not really talking about really significant changes in this area, and it's still very much business as usual when it comes to assigning an appropriate lawful basis for your processing activities. But nonetheless, some welcome clarifications. In particular, one of those is, if you're part of a larger group organization and you're sharing data intra-group for admin purposes, that's now considered to be a legitimate interest. So some welcome clarifications in this area. DSARs. So we've already talked about DSARs in the case update, and Nigel talked about them already. And I'm sure a lot of you watching and listening may have been through one or two, maybe more data access requests, and will appreciate how cumbersome and time-consuming that they can be. There are some reforms being made to the rules around DSARs, which should come as fairly welcome news for businesses. But as I'll explain, it doesn't really go as far as we think or really change existing practices too much. So, for example, those familiar with DSARs will know that the time limit to respond is 1 month, and you could extend that by a further 2 months if you can show that the request is complex. And Nigel and Claire sort of covered that already. What the bill does is it makes clear that if you're going back to the requestor to request their ID to confirm the requester's identification, or you're going back to the requestor to seek further clarification on the scope of the request. But it's particularly useful if you're holding a large amount of data about the requestor and you want to go back to that person to clarify the scope. The clock stops until you receive that information that you've requested. So hopefully that comes as some welcome news for businesses having to deal with DSARs. Another change is that your searches in relation to DSARs need only be reasonable and proportionate. So in other words, you're not entitled to carry out searches which are deemed unreasonable or disproportionate. These concepts aren't defined, but they do provide perhaps some scope for businesses to push back, maybe when challenged by requesters who are demanding large amounts of data in a DSAR. However, a key thing here is that the changes to the DSAR rules are already reflected in regulatory guidance and to some extent reflected in the case law. And in our view, what the bill is doing with regards to DSARs is essentially kind of codifying existing best practice and regulatory guidelines that are already in place. So the message, the takeaway is really the same, which is, as Nigel mentioned before, to have a robust DSAR handling process and a DSAR policy, which closely follows regulatory guidelines. And if you're doing that already, the bill probably isn't going to impact you too much. With cookies, so the cookie rules are changing. Cookies are governed under PECA, which has been mentioned before. Just to be clear, those pop-up banners that we're used to seeing on websites, they probably are here to stay. But the rules on the types of cookies that you don't need to get consent for are being relaxed somewhat. So the existing rule with cookies is you have to get consent to use them unless they're strictly necessary for the operation of the website. Going forward, the list of the types of cookies you don't need to get consent for will expand. So these are sort of what are considered to be sort of less intrusive cookies. Those that are maybe solely for analytics or site functionality. You won't need to get consent for those as long as you provide users a way of opting out. But just to be clear, this is not this won't be a straightforward change once these rules take effect, or these changes take effect. There will certainly need to be some technological tweaking at the back end of your cookie compliance mechanisms to make sure it all still is in line with the changes. But nonetheless, some welcome clarification for businesses. Automated processing, decision making. So this essentially relates to the use of AI to make decisions about individuals that have legal or similarly significant effects on them, and where no human intervention is involved. So really, it's about the sole use of AI to make big decisions about people. The rules here are being slightly relaxed to cater for a wider range of scenarios where AI decision making is acceptable, and this generally reflects the government's general sort of pro-innovation stance, which I'll touch upon later when I talk about AI. We will probably need and expect a bit more guidance on the parameters of automated decision making, but again, it does seem like welcome news for businesses. Another aspect of the bill which we think has been sort of downplayed, but is significant, is that controllers will be required going forward to have a complaints mechanism. So if an individual complains to the data controller, let's say they're a customer of yours making a complaint about the handling of their personal data, you will, going forward, be required to acknowledge the complaint, investigate it as appropriate, and then respond. So that will require some potential changes in terms of making sure you have a complaints mechanism going forward. And as Nigel said, there were 35,000 complaints to the ICO made last year. So the thinking is that some of the burden is sort of being shifted onto businesses to be able to kind of handle complaints before they are escalated to the ICO, perhaps. Also, the ICO, the Information Commissioner's Office, the current regulator of the data protection regime in the UK, is set to be replaced by a new body similarly called the Information Commission. How this impacts businesses and the way in which regulatory action and complaints will be handled in future, we'll have to wait and see. But yeah, there are structural changes being made in terms of how data protection will be regulated going forward. Perhaps the biggest change made by the bill, though, is the fines. We probably all know by now that the maximum fine under GDPR is the higher of £17.5 million, or 4% of global turnover. Currently, under PECA, which Nigel and Claire have talked through, the maximum fine is £500,000. The bill increases the maximum fine under PECA to GDPR level of fines. So they're now, or they will be, aligned when the changes come through. And there's more scope for the ICO, or I should say the Information Commission, to issue much larger fines for those in breach of the cookie or direct marketing rules. There are other changes in the bill which I haven't mentioned, and I will come back to international transfers because that's an important point. But we wanted to really highlight those changes which we think are maybe practically most relevant. But what does this all mean in practice? Well, it essentially means that when the bill becomes law, which is looking increasingly likely, it will probably be a good time to revisit your privacy policies and make sure these changes are picked up in those policies, and also making changes to your internal policies and processes now would be or when the bill becomes law, that would be a good time to revisit those processes to make sure that you've incorporated those changes. However, the chances are, if you already have a robust GDPR compliance program in place within your business, there ought not to be too much kind of heavy lifting required. And this kind of leads to an important takeaway, which is that the overall GDPR framework in the UK is not really going to materially change. The GDPR, the takeaway is that the GDPR is very much here to stay in the UK, notwithstanding these changes. And the changes proposed are quite nuanced, and as you might be able to tell, in some places, more sort of business friendly. Just to explain this further, as I talk about international transfers, but because of Brexit, the UK is obviously free to depart or diverge from the GDPR, and the bill is somewhat the first step towards diverging slightly from the GDPR. But the UK government is walking on a bit of a tightrope because on the one hand, it wants to slightly relax the GDPR, but at the same time, it doesn't want to go too far so as to disrupt the free flow of data between the UK and the EU. And just to explain this a bit further, the EU currently recognises the UK as adequate, which means personal data can flow freely to the UK from the EU and vice versa, without legal restriction or the need for additional safeguards. So if the UK departs too far from the GDPR, it risks losing its adequacy from the EU. Now, the EU's adequacy for the UK is up for review next month, but it's looking quite likely that that review date will be pushed back to the end of the year. By that time, the thinking is that the bill will be expected to become law, and the EU can then make a proper decision as to whether to continue to grant adequacy. So something that will be significant is that the bill, the Data Use and Access Bill, is looking to slightly relax the UK's standard of adequacy for data transfers outside the UK. So the European Commission, I'm sure, will take that into account when assessing whether the UK is still a safe place to send data to, and might be a bit concerned about data going to the UK, but perhaps from the UK, being more easily travelling to other less safe territories through the back door, as it were. But yeah, we are closely watching that for developments, and do watch this space. Okay, so I'm going to pivot now and talk about AI regulation. We wanted to give you an update on where we are on AI, and we've covered AI in quite some detail in recent years webinars for obvious reasons. There's a lot happening here. Starting with the UK, an important reminder is that there is a misconception about AI not being regulated in the UK, which is not entirely the full picture. AI is not directly regulated, but it is indirectly regulated through a patchwork of existing laws. So, for example, the data used to train AI involves processing personal data, and if that's the case, then GDPR is engaged, and there are specific rules in the GDPR relating to say automated decision making, which I touched upon in the last slide. Nonetheless, there is no dedicated AI specific regulation in the UK, and this reflects the government's overall approach to AI, which is to take a fairly light touch approach and is generally seen to be more in favour of kind of pro innovation and kind of minimal statutory intervention, which is also a similar approach to AI being taken in the US. That being said, a bill has been, which is reintroduced in Parliament, and it's called the Artificial Intelligence Regulation Bill. Some important context, though, this is what's called a private members bill. So without getting into too much of the detail, it's basically a bill that's introduced, that was introduced outside the government circle. So historically, such bills rarely make it to becoming law. However, they do at least trigger a debate, and we'll have to wait and see whether it does have any legs. A key area of reform in the AI regulation bill, which is quite short, is that it looks to impose a general framework for AI regulation to establish an AI authority, and to impose businesses having to designate an AI officer. But it also looks to impose transparency requirements on businesses, which include reporting on third-party data and IP used in training the AI, as well as sort of providing health warnings and even opt-outs for customers. And just as a side note, you may have read about this in the news in the last week or so, but the House of Lords are actually trying to push some of these changes into the Data Use and Access Bill itself, but the House of Commons have sort of rejected those proposals. But that's a decent reminder to us that AI, data protection, and IP are intertwined and not kind of mutually exclusive subjects. But yeah, as I say, we're at the very early stages of this particular bill, and there is a feeling that the bill may not gain much traction and may not make it very far, given the government's sort of pro-innovation stance and minimal approach to regulatory intervention. But yeah, we are keeping an eye on for developments. To contrast the position in the UK to the position in the EU has taken on a much more hands-on approach and is very much leading the way in terms of AI regulation. Just by way of reminder, the EU AI Act is now in force. So it entered into force last year, 1st of August 2024. But the bulk of its operative provisions will start to apply from the 2nd of August 2026. So there's effectively this 2-year grace period within which to achieve compliance with the AI Act. And significantly this year, certain prohibitions took effect as of February. So there are certain AI systems where the risk is deemed so unacceptable, for example, AI that might manipulate or distort someone's behavior, that they are prohibited. So those prohibitions are already in effect. And this reflects broadly how the AI Act works, which is that it takes a risk-based approach. The way to determine risk is through the Act's numerous definitions, and those AI systems that are caught within the definition of high risk, the burden of compliance obligations will be greater on those businesses. It operates on all levels of the AI supply chain, and there are significant GDPR-style levels of fines for non-compliance. So, like GDPR, where we're talking about percentage of turnover for non-compliance. And AI is defined broadly in the Act, and it's defined to capture a wide range of systems. So if you are using AI in the EU or are outside the EU, but selling or providing AI systems into the EU, then it is likely that you will in some way be subject to the Act. And if you are caught or think you might be caught, what you should already be doing is a fact-finding exercise to determine kind of what AI systems you have and how they're being used, being developed or being sold, before then turning to the Act to determine how the Act applies to you. And the final stage then would be to then implement the appropriate obligations that are specific to you to ensure compliance with the Act. So we're talking about those familiar with the GDPR kind of readiness projects. It's a very similar exercise in AI as well. Just conscious of time, but that's all I have to say. So I'll end there and say thank you and hand back to Nigel.
Thanks very much, Arjun, for that. And well, we've covered a lot of ground, and I hope you found it helpful. But we have just about reached the end of our time. And I would just like to thank my colleagues, Claire and Arjun, for their insights, and also to Dan in our marketing team for keeping us on track. And particularly, we'd like to thank you for joining us. A quick reminder that if you do have any questions following today's webinar, please do contact us direct, and we'll be more than happy to respond in the coming days. So that's all for now. Thank you again, and wishing you a good day.